Welcome to the Kratom Advocacy Podcast. Today we are back with Mac Haddow. It is his second appearance on our show, and we are thrilled to have him yet again. Mac, I'm pretty sure some of our listeners know who you are, but for maybe the few who haven't heard of your name, maybe you want to give a quick background.
Sure. I serve as the Senior Fellow on Public Policy with the American Kratom Association. I first came on board with them back in 2016 when the FDA, in cooperation with the Drug Enforcement Administration, proposed the first attempt to schedule kratom as a Schedule I controlled substances under the Controlled Substances Act. And for the last 8 years, I've been intimately involved in working to preserve legal access to safe kratom products for the American public.
And recently, there have been a lot of developments, especially since we've last spoken. I know that Indonesia has recently begun to regulate exports of kratom. Can you go into what those exportation regulations are and how they will affect consumers?
Sure. We were with a delegation in Indonesia just a couple of weeks ago prior to the formal announcement of these new kratom regulations. And I think the underlying premise that they have is that they want to protect the farmers, which I think is very important because right now, because of the import alert that the FDA has imposed, these farmers are disadvantaged in what would be a traditional commodity trading market, meaning that under the current system, because there is no valid testing that takes place on those kratom products in Indonesia that can be trusted, that the vendors in the United States have two conditions prior to paying for the shipments of their kratom exports. One is they want to be able to test those products so that they are assured that they're free of the contaminants. So the steps that the Indonesian government is taking to ensure that these products that are exported from Indonesia are excellent and welcome news. The second problem, however, is that the FDA's import alert is the one that puts the risk on all of the shippers rather than the farmers, meaning they're not going to get paid until it makes it through customs. And of course, the vendors aren't going to pay in advance for a shipment that they can't receive at their manufacturing facilities, or the import broker receives it so that they can then transship it to an actual manufacturer. That displaces and disrupts the traditional trading commodity platform that most people can be assured of is going to work. And the farmers are the ones that get disadvantaged because those that are taking the biggest risk, those brokers over in Indonesia that are then shipping it to the United States, are assuming a very high level of risk, which is derivative entirely by the import alert. These new regulations are founded on one premise that I think that the Indonesian government did not fully understand. They believe that by instituting the regulatory practices that improve the quality of the material that's shipped, making sure that it meets testing requirements, that it adequately identifies the metrogeny content of the exported product, that it's free from contaminants, would lead the FDA to lift the import alert. That's a view that is simply not supported by the facts, because the FDA has used as a pretense that they're concerned about the safety of those products. But there hasn't been an outbreak of salmonella since 2018 that involves kratom. There have been numerous outbreaks of salmonella for commodities that are consumed every day by the American public, and it doesn't call for the FDA to shut down all of the imports of lettuce or fruits or other kinds of typical produce that consumers purchase. This is a position that the FDA has taken, which is a false position. And yet the government officials in Indonesia really believed that the FDA would listen. I pled that case on behalf of American consumers, that they cannot rely upon that, and hopefully they'll make some changes that are needed in their export regulation. Some of those export regulations are going to cause a couple of onerous things. First, the capacity in order to produce safe kratom raw materials in Indonesia doesn't meet with those that are approved for this purpose, doesn't meet the demand. And so you're going to have a tourniquet on supplies that will come out of Indonesia for the next 4 months or so. They claim that they're going to be able to modify and adjust these regulations within the next 3 to 6 months. That may be too long, because the inevitable result of farmers who have raw materials that they supply to producers, but the producers can't put them through their processes the milling and the powderizing of the kratom, there will be a natural backlog. And when backlogs like that develop, nobody's getting paid. And that will inevitably result in a black market being developed. And as much as we would like to think that that couldn't happen, it will, because of the economic pressure. And when you have black markets, there are no controls. And so we think that that's really something that should have been phased in, where they develop capacity. But the right way to do this, while they're building out capacity to supply the demand globally for kratom raw materials, they should have phased it in and done testing, rather than rely solely upon capacity for the processing of the kratom powder material. They should simply have a test, and that would assure the purity of the kratom coming to the United States. I hope that they do that as a modification to their current import alert. The second problem is one that is more economically driven for processors, in my opinion, and that is that they established a size limit on the kratom crumbs or crushed leaf that would be exported from Indonesia for extract products. And right now, Indonesia doesn't allow for the extract products to be manufactured, raw materials to be manufactured in Indonesia. I hope that changes as well. So the primary supplier of raw materials for extract products is either in India or the United States. And the size requirement that they have put on the exports of those raw materials is simply too small for it to be an efficient extraction process. The extraction solvents that they use have to be able to saturate into the crumbs. And if they're too small, they do not efficiently do that. You need to have them as larger. And by the way, there is no issue with contamination with extract crumbs, because the extraction process completely removes the entire microbial load, and you're left just with pure metrogenine at the end of that process. So I think that rather than what they've done, which is to institute a set of regulations that's premised on the false assumption that the FDA would lift the import alert, they should have put more thought into this. They should have listened more carefully to what we've been asking them to consider over the past 6 months. And I'm hopeful now that this has been done, that we can come back and work with the Indonesian government, certainly with the new government that's coming in, and solve this problem for the long term. Unfortunately, there's not a very good system in place that's going to solve the disruption of the process. I understand, and I think consumers have to accept, that farmers need to be paid a fair price. And part of these regulations require that there be a minimum price for basic kratom raw materials, with an increase in that price based on the metrogenine content of the plant material that's produced. I think that's a fair system. It's not the free enterprise system, which is dictated by both quality and market forces. But I think in an interim step, we should certainly preserve the livelihood of those farmers. The other problem is that the export system, as we understand it currently, and I will acknowledge we haven't gotten the full description here exactly of how it's going to work, but what our understanding is that if you are an exporter and you are qualified under the government system, you pay in advance based on purchase orders that you have in hand, and that will allow you to export. That will squeeze out the small players, because if you are a processor in Indonesia, you're going to be taking care of your big players and your big volume customers rather than the smaller ones. And I don't think it's appropriate for small kratom vendors in the United States, who are otherwise fully capable of producing safe products, should be excluded just because of an economic restriction that's placed there in Indonesia. I get it that money plays an important part in the supply chain of all commodities, but it should not be unfair. And I think these regulations, as they're currently constructed, are unfair. And we hope that the government will be listening to us over the next couple of months.
We've just answered about 17 of my questions. That was wonderful. And I wanted to ask you, I've read, it's going around on Facebook, that price is projected to steeply increase. How much is this true? For how long will that be true? And do you have any estimates as to how much that price increase will be?
Well, there'll be a natural increase when you put a floor price on the metrogenine content of $3 per kilo to the farmer. So that will bump the prices a bit. And again, I think justified. The second level of the price increase will come when you have to put the kratom raw materials into the trading export system, which will require the payment of a tariff to the government. And again, I've long advocated that that's an essential part of making sure that the government has an enforceable quality standard. They have to have the resources in order to do that. But the real cost increase is going to come in the restriction of the supply, because there's not going to be enough capacity, as I referred to earlier, to produce the kratom raw materials needed for the demand. And by the way, if you do the crumbs, the crushed leaf restriction, then you're going to have to ship a lot more of those smaller particles. And that's going to consume a lot of the volume that's already built into the system, for which there is no good processing capacity. So I think you're going to see, for at least the next 4 months, significant supply chain disruptions and potentially very high price increases that hopefully after that period of time gets resolved, as more kratom processors in Indonesia qualify for this new government regulation program, that will be able to catch up with the demand. But I'm not optimistic that that's going to happen. And those various factors will drive a significant price increase for the short term with American consumers.
All right. And could we mitigate some of these price increases by, say, just domestic growth? I know Florida has been working on kind of becoming self-sufficient. It seems like a tall order, because you're not going to be able to supply the way Indonesia does. But are we moving in that direction, do you think?
Well, I think that there are two opportunities in the United States. The first is in Florida, where they have planted some trees. There's a mixed reports about the quality in terms of the mint content of that plant material, and there's some interesting studies being done about what the actual ratio of mint content has in terms of developing a product that is effective for consumers, to meet the effects that they're seeking with the kratom product, whether it gives you that energy boost or whether it elevates your mood, and in large doses, whether it actually has the analgesic effect. I'm waiting to see that. I hope it's true. Probably the bigger opportunity is in Hawaii. Florida is restricted in terms of the area in which it can grow because of the frost line. And so anything south of a particular line that doesn't have freezes that would kill the kratom trees is probably fair game. But in Hawaii, you don't have that problem. It would be a very big anomaly if they did. But they have a kratom plantation over there which has successfully passed the pilot stage, and they're capable of growing millions of kratom trees in Hawaii. And I'm looking forward to that being the next opportunity for domestic supplies of kratom to be grown here. And by the way, the Hawaii farmers who developed their plantation actually did it by cloning the plants rather than just replanting them from Indonesia. And they are plant geneticists, and they understand exactly what needed to be done. And they've had outstanding success, at least in the pilot phase. And now I think they're poised, depending on what kind of investment can be made over there in Hawaii. And it's important to note that both in Florida and in Hawaii, they have unique situations where lots of land is available, and challenges with crops that used to grow in those areas that have lost their economic viability. Or in the case of Florida, you had a canker that wiped out the citrus growing region. So I think there's real opportunity here that can be seized by forward-thinking regulators in those states to facilitate this growth in kratom growing of trees. And I think that will serve the American public well. And I think it will provide a needed and essential competitive situation for Indonesia to understand that it's not just a market that they capitalize. And by the way, I think that's already starting to happen with Thailand coming on board. The big problem with Thailand, since they decriminalized kratom and allowed for its growth, while they've been instituting a very specific supply chain, which is very similar to what Indonesia is now trying to do, they're ahead of that game. Now, the beef with the Thailand kratom has been that it's more costly than Indonesia. But this new regulation enters into a new paradigm where you're going to have now competitively priced kratom raw materials, and Thailand may become a major supplier of kratom raw materials to U.S. manufacturers and globally for that matter.
Have your relations with Koperbu evolved since we last spoke? Do you know how they might feel about this? I reached out for comment, but haven't heard back yet. I'm wondering how they're feeling about all of this.
Well, Koperbu is only one of many of the growers groups that exist in Indonesia. And my opinion is that all voices need to be heard at the table. Depending on who you talk to, Each one of these groups will say, well, they're the biggest, largest, most influential. I can tell you that we in the past have dealt with Cobra Boo. I know that they have an operation here in the United States, and folks like Paul Kemp and Daniel Torres, whom I don't know Daniel personally. I know Paul Kemp. He is a very, very good man. And I think I'll give that
I agree.
to Daniel too, with one caveat, and that would simply be: it's easy to take pot shots against the AK or me personally from behind a keyboard. I wanted him to come forward and publicly have a discussion about what his concerns are with the AK, rather than just doing it behind that keyboard, because I think discussions are important. And I'm sorry that he declined to do that. But Koperbu, when we were working with Mr. Johannes in Indonesia, was a very difficult situation, because there was not much that we could rely upon that proved to be accurate. And just as one example, and there were many, in front of multiple witnesses, Mr. Johannes said that he had no personal financial interest in the farming of kratom or in its processing or exporting to the United States. That simply is not true. It never was true. And yet he said it in order to build credibility. And he said it in meetings that we were not the only parties to. And even after we had what I would characterize as a turbulent discussion about the integrity of those claims, he then invited a couple of members of our delegation on one of our trips to Indonesia, after he had said that he didn't have any financial interest, invited us to a meeting that we had at the airport in Jakarta, where he brought an investor to come to us, and during the meeting started telling the investor about all of his investments and his capabilities and what he was building in Koperbu, all of which contradicted his public statements to us. So I don't know what it is, and maybe there's a cultural difference. I don't know, but I can tell you that I rely upon people's integrity. If you can make a mistake, fine, own that mistake, but don't lie to me and then tell me, oh, well, I didn't really mean that, or I didn't say that, as a way of getting out of being accountable. And I think that's the most important thing. I hope that Mr. Johannes would be willing to have an honest conversation that really aligns with the reality of what he's doing in the United States, because no one will convince me that Koperbu, led by him, is not in a financial arrangement with U.S. vendors with a state-based franchise system, which Koperbu is now actively marketing in the United States, and of which Paul Kemp and Daniel Torres are a part. They should just own that and freely acknowledge it and be accurate about it. And by the way, I'm not attributing Johannes's statements to either Paul or to Dan. I think that they never said that to me, that they don't have a financial interest. I think it's clear that they do, and they have a right to that position. But Mr. Johannes does not. If he wants to claim, in order to get credibility in discussions, that he doesn't, the only interest he has is altruistic in trying to protect the farmers, when that doesn't prove to be true. And that's unfortunate.
We're trying to set up a conversation, if you're willing, later between Mr. Yo and Daniel and you, and hopefully we'll be able to get that scheduled someday. In the meantime, have you heard about American vendors not paying for shipments due to claims that the containers have been seized, when in reality they haven't? Have you heard about that at all?
Well, I know of only one circumstance where a payment was not actually remitted to an Indonesian shipper, because the shipment was contaminated with salmonella and therefore rejected. One of the problems in the past, and hopefully this new regulation, if it's properly implemented, will solve much of this problem. But one of the problems has been that there's not good testing that's done. And in this particular case, there was a shipment made, a very large shipment. When it was received, it was tested, and it tested for salmonella. The shipper claimed that wasn't true, and so they retested it. And in fact, they consumed about 2 tons of the 20 tons that had been submitted in order to remediate it, and were unable to do so. Now, that's a business dispute between two parties that have a contract. The demand was made of me at the American Kratom Association that we should somehow intervene and become a mediator in that kind of deal, and I'm not going to do that. And I know that I caught the ire of both Mr. Johannes and Mr. Hendricks about that situation. So, this is a situation that business contracts should be handled in a professional way. And I think that means the parties are involved in it, and don't try to find assistance from the American Kratom Association for those kind of contract disputes that are properly left with a legal mediation or a contract dispute that's litigated in the courts. And I recommended that at the time, and that, of course, has not been satisfactory to either the PPHI group or Cooperaboo, both of whom then subsequently, in a sort of a tantrum, recommended to the government that they stop shipping and exporting kratom raw materials to the United States, showing how myopic their view is, that just because they have a contract dispute, that somehow should impact everybody in the universe of kratom, and particularly disadvantage kratom consumers that they say that they're trying to serve, and more importantly, disadvantaging farmers. You can't have a supply disruption that doesn't allow for farmers to do the only thing that they're able to do in the locations where they are farming kratom. They don't have any options. They can do kratom farming. That's it. And they should not be disadvantaged because of the temper tantrums of a couple of people that are in the supply chain, but really shouldn't have that kind of influence.
So pivoting to domestic affairs, in Utah's KCPA, there's a clause that prohibits the mixture of kratom with other psychoactive substances that could be injurious to the consumer. Recently, I believe I've learned, correct me if I'm mistaken, that this clause is being used to take products off the shelves because it's mixed with kava. Why is kava included, and can you elaborate on that a bit?
Well, first, I'll tell you that the Utah law, consistent with other KCPAs, I think most all the 13, contains provisions that says that a kratom product that is mixed with another substance that could be injurious, including controlled substances, and any others that are mixed that create a danger to consumers, are prohibited. That is a standard that is consistent with federal law and with state law. And it's interesting in this particular case that the Utah Department of Agriculture and Foods determined that the mixture of kava and kratom together were potentially dangerous, and therefore they delisted those products. I think there were 8 or 10 products that were delisted. I was asked by, as you know, the Global Kratom Coalition to involve the AKA in this dispute. The premise upon which the objection was raised by the Global Kratom Coalition was, first, that it is the burden of the state of Utah to prove that they're dangerous. That upsets and turns on its head all regulatory policy. It is the obligation of a manufacturer who enters the marketplace with a product, and this is consistent with federal law, that if you have a reasonable basis, as long as you meet other qualifications for market entry, if you have a reasonable basis for safety and for its intended use, which is labeling, then you can enter the marketplace. And so the burden would be upon those companies that are marking kava kratom products to go to the state of Utah and to demonstrate with evidence, whether it's long-term consumer safety evidence that documents that there have been no serious adverse events from the consumption of these products, and any peer-reviewed science that exists, and published articles would certainly be helpful to do this. The demand by J.W. Ross, who is the chair of the Global Kratom Coalition and the founder of Botanic Tonics, was that I should somehow, and the AK should somehow, get involved in this. Why would we do that? I mean, this is an obligation by an individual vendor. And of course, the allegation is that somehow we have a different standard on these things, and we do not. And the AK's position has been consistent on this, that we want to protect consumers. Now, the question about kava and kratom, it's a simple equation. There are scientists in the field that say that because kava and kratom, where there's no peer-reviewed science published that documents their safety, that it's a matter of concern. And there are some scientists who say that that combination is potentially injurious to consumers and is therefore adulterated. Now, here's the premise for that. There's lots of scientific articles that document the toxicity of kava to the liver. There's lots of separate research that document the potential toxicity of kratom to the liver. What we don't know is whether the combination of those two products would have some sort of synergistic effect. I don't know the answer to that. And when I asked J.W. Ross, who claimed vehemently to me that he had the evidence, that I should not even raise this question, because I did raise it in the context of our discussion about the Florida proposed KCPA, about how we should frame this language. And he told me that he had that scientific literature, but he wasn't going to share it with me. And I thought it was pretty interesting. Now he's coming back saying, oh, well, you should come to our defense. I can't do that because I don't have the evidence. He refused to give it to me. And on top of that, by the way, uh, this is the individual and the organization that he operates, the Global Kratom Coalition, that has been hypercritical of the current KCPAs that have been passed in the states, claiming that there is no way that those states will enforce against dangerous products because the self-regulation model doesn't work. J.W. Ross has committed to disrupt all 13 of the KCPAs that are passed by going into those states and trying to pass stricter regulations. And now, isn't it ironic that he now steps up and he gets bitten by a state that he claims is simply can't control any of the potentially dangerous products in the marketplace? And Utah did it. That self-regulation model apparently works. And now he has to account for it. I'm not saying that their decision is correct. I'm saying that they took an appropriate step under the law. And here's the interesting thing. In their defense, they said that not only did the state have the burden to prove that they were wrong, which is nuts, they're saying that the state acted inappropriately. Well, the state has regulatory authority that says notice the company. And then, of course, there's an administrative procedure where the company that has been delisted can simply appeal it. Let them do that and let them do it under the correct procedures. Don't look to find other people that suddenly you think you need and say, oh, let's come back. Let's get the AKA to come in and help us. We're ready to help any kratom manufacturer that is appropriately manufacturing a product for which there is evidence and data that supports the safety of their product. And where we can do that, we'll certainly do it, but not when someone tells me they're not going to share the evidence with us because they did it in a fairly haughty way. And now all of a sudden he's come knocking on our door. So I'm just not inclined at this juncture to get involved in this until and if there is compelling evidence that they have to produce, they being any of the delisted product manufacturers, and if we could help with that. I can tell you that we plan at the American Kratom Association to have a panel discussion on this that includes scientists who have the opinion that the combination of kava and kratom are potentially injurious to consumers and therefore adulterated. And we're having that at the Leadership Summit in November in Providence, Rhode Island. So we're going to delve deeply into this. We want to find out as best we can what the best approach to this is, what the accuracy of the information is. And so we'll see where that falls out. I'm not against kava kratom products. I'm not blessing them because I don't know the facts yet. And I was not allowed to see the facts that they claim to exist. So we'll see how that develops.
Okay. And have we proven the safety of kratom products, or maybe not kratom products, but products with augmented 7-OH levels? Do we have, in your opinion, peer-reviewed studies that support the healthfulness of their presence on the market?
So I am not aware of any peer-reviewed scientific evidence that documents that 7-OH in its isolated and purified form is a safe product. That is absolutely going to be the obligation of the 7-OH manufacturers. What I don't like is that the 7-OH manufacturers call it kratom. When you isolate a metabolite of the kratom plant and then you enhance it, it is no longer a kratom product. And I've been advocating both with the 7-OH manufacturers and with legislators to adopt regulations that say you cannot market it that way. You can't call it a kratom product. If you define it that way, then it is the obligation of that manufacturer to meet the standard that I referenced earlier, which means that they have to document with evidence and data, which, by the way, could include the fact that the 7-OH doesn't have any serious adverse events. That's what they're telling me right now. I personally believe that is a misplaced judgment, because right now, if you go to the FAERS database, that's the FDA's adverse event reporting system, I don't think that the reporters, meaning the consumers or the medical professionals, or now the trial attorneys who are frequently making complaints, are differentiating between a 7-OH product and a kratom product. So there may be adverse events that are hidden in that data. And I think that when you separate them and say you cannot call a 7-OH product that doesn't have the predominant alkaloid metrogeny in it, or exceeds the 2% level of the overall fraction of the alkaloids, you can't call that kratom, and you shouldn't call it kratom. And then we can start to divide out what the evidence and data is. I'm strongly, at this juncture, uh, pursuing this strategy to force them out of calling it a kratom product, and I think that'll eventually be what we do. And then they have to make their own case for its safety.
Does that preclude you from working with companies like Seven Ohms as of right now? Would you be interested in starting talking with them, or have you begun any type of relationship with any 7OH vendors or people selling 7OH products?
So I would not call this a relationship. I work with people and all of these issues. I talk to anti-kratom people that believe that kratom has killed their loved ones. I just was in a discussion yesterday with a documentarian who is doing a what I would characterize as an anti-kratom piece. She's asked me to appear in this documentary. I'm willing to do that. I think that we need to hear both sides. That is equally true when we get into discussions about 7OH. I've expressed my opinion to the group that represents the 7OH people about how they are inappropriately and inaccurately characterizing their products as 7OH. I have strongly, or as kratom, I'm sorry. I have strongly objected to the product formulations where you get a vape pen with 7OH, because kratom doesn't help people, nor I don't think 7OH does either, through vaping. I think that it's through your gut. And if we're going to have a reasonable discussion that's comparing apples to apples, we've got to make sure that we understand what the effects of kratom are and how they are metabolized in the body. And just because you can create a more powerful effect of a kratom product, or in this case, a 7OH product, doesn't justify what you're doing. And I think they need to be far more responsible along the way. I've expressed that opinion strongly. Now, I know that I will be demonized by my friends at the Global Kratom Coalition. Oh, he's talking to the 7OH people. I am. I'm trying to get them in a position where they'll accept this. It doesn't mean they'll listen to me. And at the end of the day, it's just like discussions we had with Johannes and Copper Boo. We may part our ways, but I'm at least willing to have the discussion until the point becomes that we come to the point that we just simply can't agree on anything. And then I think those discussions will terminate. Right now, I'm optimistic that they're listening and understanding the problem. And I hope that we can get some control on their end over these outlandish products that are being developed right now and inaccurately and inappropriately characterizing them as kratom products.
One viewer wants to know in regards to the California bill.
As an aside to our listeners, Bill AB 2365, created by the Global Kratom Coalition, is proposed California legislation that would more strictly regulate the state's kratom market. This is a gross oversimplification, but proponents of the bill say that its ratification would protect consumers and enhance the safety of California's kratom industry. Detractors of the bill, such as the AKA, say that its terms would impede vendors' ability to compete and innovate.
How is that bill anti-competitive? I believe you called it anti-competitive before.
The anti-competitive provisions would have allowed for very few large manufacturers to survive the regulatory scheme that was imposed, including the costs associated with registering your products. Because if you assume that there are 50 kratom manufacturers that would qualify, that could qualify, which is what the number is in the state of Utah, which has 4 years of experience. If you assume that there are 50, then they have to spread out those costs that are articulated by the health department with millions of dollars. That would have driven a cost for registration of about $113,000 in the first year and $83,000 a year after that. That assumes, and I think inaccurately assumes, that all 50 would then decide to participate. Every time you get a drop off of that 50, then the costs burgeon on the other end. And in the end, you'll have probably 10 or fewer that are willing to invest that kind of money into that California system. And you're looking at astronomical registration fees. That was by design. No one can convince me otherwise, because I argued strongly with the Global Kratom Coalition, this is going to create a disaster in the marketplace. They didn't care. And that's because, in my opinion, there's one beneficiary of the Global Kratom Coalition, one that's a big player there, and that's Botanic Tonics that founded it. They fund it largely. I mean, it's overwhelming what the money they put into it. And I don't think that that serves the consumer in California. It would certainly eliminate anybody but the big dogs in the kratom industry. And even then, you might not get them all playing because of the onerous fees. Now, the explanation was provided by the Global Kratom Coalition after the bill was held in suspense, which officially killed the bill. They said, oh, it's because the health department really didn't want it. That is not true. I've spoken to the health department people, and they were willing to accept this responsibility. And they said the costs were driven by the specific provisions of the bill that the Global Kratom Coalition wrote. There's only one reason why that bill failed, because the Global Kratom Coalition was trying to corner the market in California to help just the big vendors, and they didn't care about anyone else. And most importantly, they didn't care about the consumer, because the consumers are the ones that end up being disadvantaged because you have fewer products on the marketplace, you stifle innovation, you completely take off the market any small business provider along the way. I think there's common agreement that we were right about that. We had to hire a lobbyist in order to go out there, and we're spending money to fight against an anti-competitive provision from a group that claims to be pro-consumer. That doesn't pass the smell test in any way, shape, or form. And they wouldn't listen. We tried hard. There were some things that we were able to negotiate, but the big issues, the really big issues that impacted consumers, really fell by the wayside in the interest of the benefits, the economic benefits to just a few Kratom consumers or a few Kratom products, which obviously is now a problem. And by the way, I'm not so sure, based on what Utah's decided, that even Botanic Tonics products would pass the muster test at this point.
All right. Pivoting, what's the governor of Rhode Island's rationale for vetoing the KCPA? I heard you had a meeting with him recently. If you can divulge to me what happened and what's going on with that.
So I met with the governor of Rhode Island yesterday. He was engaged in the discussion, was very interested in learning more about Kratom. He indicated to us that in our meeting that he had listened to and relied upon the information from a number of physicians in Rhode Island. And I explained to him that those opinions were framed largely by the FDA. And that I told him that the American Medical Association in their House of Delegates had considered a complete ban, recommending a ban on Kratom federally and at the state level. And they rejected that, and in fact passed a resolution that said you should not criminalize people, ban Kratom, and that's what his state does. And when I told him that he wanted more information on it, he committed to finding a pathway for us to have an appropriate regulatory scheme in Rhode Island. And I think that we actually had moved mountains to do that. We had worked with his policy staff. We might have to do a few more tweaks, but I'm confident that the governor, his commitment to us to review this again and to accept his recommendations will lead to a final passage and his signature on the bill in order to decriminalize and remove the ban in Rhode Island.
All right. And update on the Facebook restrictions. People have been talking about them for quite some time now, and they don't show any sign of stopping. I wonder if you got a position from Meta, or because I'm getting ads for, ketamine, and I think maybe even I saw some 7-hydroxy products, but for some reason Kratom is verboten on there now. Is there an end in sight to this?
There is. I think that we went through this a couple of years ago and went through the same negotiation process. I think the FDA is leaning heavily on Meta on this issue, and it's certainly been inflamed by the recent pronouncements by the FDA about their vacillating position on Kratom. You have on one hand, you have the FDA acknowledging in a study that they conducted on their own about the dose finding study to determine whether it was safe for humans to consume Kratom so they could conduct their dose find or their human abuse potential study. They got to 12 grams of pure leaf material consumed in a 5-minute period, which is a huge amount to do in that length of time. And they saw a minor adverse event characterized as nausea experienced not only by the Kratom cohort, but also by the placebo cohort. Consuming that much material in that length of time it's going to cause you to get sick. So the FDA concluded they stopped the study, not because there was a serious adverse event, but they'd gotten to 12 grams when they projected in their initial view of this study that you would see at 6 grams people going into seizures and writhing on the floor. And they didn't get that. And I think that opened up the eyes of some of the scientists at the FDA who already were more balls and strikes kind of people, not the people in the commissioner's office that are dominating this policy. So we've written a letter to Commissioner Califf advocating that he convene a stakeholders meeting that's public and that we let scientists and legal experts and regulatory experts to actually determine what the safety of Kratom is And we're hopeful he'll listen to that. And part of that will then have a downstream effect on Meta as to whether or not they're going to continue this crusade against Kratom that they've launched. It is disappointing to me that they haven't already lifted it, because they did a couple of years ago when we objected and showed them the science. We're going through that process right now. But there's obviously inconsistencies. You see products that are openly marketed on Meta, Feel Free as an example. Now, I think the way they get around it, based on complaints that I've received, is that they don't call it Kratom. You look at the front of the Feel Free bottle on their major product line, it just says Oriental Herbs, I think. It doesn't say Kratom. But if it did, they wouldn't be on social media right now because of this ban that Meta has imposed. I think the ban's ridiculous. I hope that they'll reevaluate their position shortly, and we're going to continue to work with them in order to try to get to a compromise on what they're doing right now.
Cool. And your website mentions the FDA's abuse of its authority in regulating Kratom. Can you provide some recent examples?
So the FDA just updated its FDA and Kratom webpage again earlier this month. And there is a law. The statute says that if you are going to make a determination, if an agency, a regulatory agency, makes a determination about any substance, and they say, as the FDA says, is that all Kratom is adulterated and therefore illegal to sell, they have to go through administrative rulemaking in order to draw that conclusion, which requires public comment and a protracted evaluation of the truth. They circumvented that entirely and just put it up there. It is inconsistent with the National Institute on Drug Abuse policy on Kratom. It is inconsistent with the actual science that has been documented by scientists, independent scientists in this field, and it's inconsistent with the consumer experience. There is a bias by a leading policy person in the commissioner's office who is anti-Kratom, and he's been able to overwhelm the commissioner's thinking on this. And we're hopeful that the commissioner will set that aside, listen to the experts, have this stakeholders meeting we've advocated for, because right now the FDA is wrong on the policy, they're wrong on the science, and they are harming consumers in the marketplace right now because they are trying to ban and demonize Kratom.
Okay. Would you say that the legality of Kratom is more threatened or less threatened than from when we last spoke?
Well, I think that every day there's a balancing act that goes on, and it's a push-pull system. As the FDA observes that there are comments made or publications that are peer-reviewed literature that's published, and that NIDA makes statements, they say, and new research coming out, they see their position eroding. And instead of saying, well, let's take a balanced approach to this, they push back harder. They change their FDA and Kratom website. They change their narrative. They put out a consumer advisory about OPMS black shots, and they said that these should never be consumed by the public. They referenced in that consumer advisory repeated complaints about it. I went back to their FAIRS database. I can't find one, not one. Now, what is this, a secret database that they're maintaining? That's not what they're allowed to do, by the way, because they're supposed to be public. They make it up. And I think that to the extent that they're driven by trial lawyers, and I think that's a fair assumption based on the very vocal activity by the trial attorney bar, who pick cases that they want to then go force settlements on Kratom manufacturers, I think that's part of the problem, and the FDA is facilitating it. And that's not the job of the FDA to become a party to a lawsuit in private litigation on a product liability claim. That's why we have laws to determine that and let courts determine it. The FDA has no place in putting their finger on the scale there, and I think that they need to be called to account for that.
So who are these trial attorneys, and how do we stick it to them?
Well, I respect many of these people. They're in business, and the trial attorneys have gotten a bad name because they exploit people. If the trial attorneys were actually doing their job and they were looking for people to sue, and remember, they're looking for a payday. If they were looking for the culprit to sue, and let's take a perfect example, that case in Florida, where the consumer was purchasing a product called Space Dust, came in a enhanced Ziploc bag with a Sharpie scrawled on it, Space Dust, with not one letter of warning or instructions for use. The FDA knew about that product for over a year. Why don't they sue the FDA for allowing a dangerous product to be on the marketplace? Why don't they sue them? Because there's no money at the end of the rainbow for that. They go after the pot of gold, which is the manufacturers. And so what they do is they create this narrative about the about what the cause of death is and who's responsible. And of course, you can't. There's one thing you can't do. You can't sue a fentanyl dealer that spiked a kratom product with fentanyl that caused the death. There was a case at American University by a doctor, a mother, who testified in the Ohio hearing that her son had died of a kratom overdose. And then she said, but it was fentanyl laced. Now, you can't sue that drug dealer on the street that mixed that product together. And so they go after the kratom manufacturer, claiming that that is the responsible party. You look at the cases that are filed now, all of the complaints are consistent. The FDA says kratom is dangerous. That's what they say. They point to the circular reasoning that there are other cases out there that are proving that kratom is, that the medical examiners say that kratom is dangerous. This is the biggest fallacy in the world. You look at the cases where medical examiners have made the determination that kratom is dangerous. They do not follow any consistent post-mortem investigation practices. There's no consistency in this. And when you look at the widely vacillating tox reports and you say, is that even reasonably a good conclusion? The answer is no. Most of these are far under the 1,000 nanograms per milliliter that even the I'll call them anti-kratom NMS labs produced. And yet medical examiners are checking the box. We finally sued one of those medical examiners in Ohio, and the two coroners in Ohio amended their finding after they got sued and said, well, after we reviewed the more current literature, we agree that this was an unfounded conclusion, right? Yeah, that's because the medical examiners don't do it. And in a recent interview that's now up on a documentary that was published yesterday, the NIDA scientist made this point, that you have elected medical examiners and coroners around the country that do not know what they're doing. And they, by the way, they're well-intentioned. A parent comes in and says, my kid died, and what do you think it is? And it's easy to check the box and say that it was kratom. Perfect example of this is the Tampa Bay Times that did their deadly dose series. And they claimed that there were 46 cases where kratom was solely responsible for the death. They talked about how they went through a very detailed methodology to acquire the database, because in the state of Florida, there's no central reporting mechanism for these deaths. We took that methodology and we did exactly the same thing. We replicated it. At the end of the day, we came up with 51 suspect deaths, 5 more than what they said. So we asked them, let's compare case by case so that we know what we're talking about and we're not going to misstate which cases you relied upon. They refused. Now, the reason they refused is that we've done an examination of the toxicology and autopsy reports, and we find that most of them, if not all, are bogus. They're simply medical examiners who checked the box because it was convenient to do so, and they see that the FDA is down on it, and they're listening to news reports, and they say, well, kratom was present at the scene, and some of them are just that blatant. Oh, there was a report by the investigator. There was a bag of kratom next to the bedstand of the decedent. Is that a basis for saying that kratom killed that person without examining the underlying medical conditions, other substances that were involved? In some cases, when the tox report was sent out, in the Florida cases that were relied upon, the Tampa Bay Times rag, and I'll call them a rag because they will not account for what they did. They in the tox screens, the only substance that was asked for in the tox report was metrogeny. What?
Wow,
how in the world can you get a valid conclusion if the only substance you're testing for is metrogeny? What else might that person have been taking that might have contributed to that death? So I guess the bottom line here is the people that get cheated in this process are the families, because the families deserve to know what the real situation was with the death of their loved one. Secondly, the truth gets compromised, because we're not finding the truth here. We're finding allegations that are unsubstantiated, and trial lawyers leap on this because they want to find that case that they'll take. And I hear plenty of people tell me that they're only taking the big ticket cases. They're not really in this for the altruistic purpose of taking every case that they want to claim was kratom related. They're only taking the ones they think they can get a big settlement, which means they're targeting specific manufacturers that they know they can get a settlement from. What profit is there for them to go after a small manufacturer? So that's disappointing, because again, the casualties in all of this are the families who are grieving. And I certainly understand that if you've lost a loved one, and by the way, if we find out if it truly was kratom, what are the circumstances? What was the product? What was the product formulation? What are the concentrations? Then we should know that too. because that would inform us about what the right regulatory methodology should be. But unfortunately, we're not in that position right now because we don't get the truth. We get a conclusion that is based on circumstantial and sometimes more shoddy evidence than that, rather than conclusive talk screens. And the trial attorneys are exploiting that, and that's unfortunate in the condition we're in right now.
Do you use Kratom?
I do.
Like, what's your grams per day, or like once a week, or viewers are
No,
curious?
I take it probably 6 times a week. I When I was young and very stupid, I was a desert bike motorcyclist, and I banged myself up pretty good. I also got in accidents on my street bike that ended up with bad hip and bad knees. And so now, and there's arthritis because I'm old enough now that I suffer from arthritis. I find kratom to be terrific. I take 4 to 6 grams a day, and I'm not suffering any adverse events that I've experienced at all. Some people may dispute that and say, "Well, he's daft," but I'm using kratom regularly, and it's one of those things that helps me considerably.
Cool. What's one book that changed your life?
Oh, that's it. That's it. You know, this will surprise some people, but I read Catch 22, and
Hmm.
at the time that I read it, it struck me as sort of an example of how the world sometimes goes off into the craziness. And in the work I've done in politics, I've always been reminded of it. I'll be sitting in meetings and wonder how in the world this decision came about. And I think of the Catch 22 scenario, that the ridiculous connections between the hierarchy of power and that kind of thing. So I've always reflected back on that book in terms of its response to the world we sometimes live in with respect to politics.
Thank you for helping to untie some of that confusion. And final question: any remaining thoughts you want to leave the viewers with?
Well, I'll say this. I think that we're going through a period right now of a little bit of contention that between the groups that are out there. It is our goal to represent consumers, and to the extent that we need to partner with any group, we'll do that in order to advance the cause. We'll set aside personal disagreements. We'll set aside even areas where we have a legitimate basis to have offense, because it isn't about personalities. It's about what the goal is. And I think that if a group comes and demonstrates their fidelity to that commitment, we'll share and work together with any of them. I know that the current situation with the Global Kratom Coalition, for example, is untenable because there's no honesty or integrity that's associated with any of these discussions that we're having with them, because they never seem to be what they are 2 minutes after the agreement's made or a discussion has taken place where you walk away thinking we made progress. I think that's true over in Indonesia. We've worked hard to try to preserve an opportunity for safe kratom raw materials to be shipped into the United States. And we've seen that compromised, I think, by the regulations were just put into place. We're going to work hard to try to correct those where we can. And I think there's an openness over there to actually do it, despite some of the chatter by some of these groups like Koperbu. I think that the bottom line is that all of us should look at and examine what is the best course of action to protect consumers. Because I've sat in too many hearings where I hear the heartfelt expressions and testimonies of people whose lives have been saved by kratom, and who say their lives have been, the trajectory of their lives, their quality of life has been improved because of this plant. Now, it may not be for everyone, and people may not find it to be something they want to have a long-term kind of relationship with in terms of taking kratom. That's fine, but don't restrict the ability of another person to make a free choice about how they're going to address their health and well-being. And that's been from the day that I first got engaged to help with fighting back on the ban that was proposed by the DEA and the FDA in 2016. I have been amazed at the people that have showed up to be advocates, and I think that we've gotten a little bit fat and sassy because we've had such great success in preserving the legality of kratom. I think as a result of that, today we're in a better position than we've ever been. We're going to continue to refine the regulatory pathway to allow safe kratom products to be accessible to the consumers. But they're the people we fight for. And I know that there are disagreements between people who have different views about product formulations, about what the regulatory scheme should be. But we should set aside most of that. There's some core things we can't, but most of that should be open to discussion so that we protect consumer access. This should not be, in my opinion, an exercise where we try to restrict the product formulations based on the opinions of a particular manufacturer who wants to gain a competitive advantage in the marketplace. Let consumers decide what they want. And as long as the product is safely manufactured, that it's labeled properly, and that they have the notice on what the potential hazards are, then there's a personal accountability that plays into it that is not the fault of any manufacturer or of the kratom industry in general if those individuals choose to violate that because of their free agency. So I think that's the bottom line. The American Kratom Association remains committed to working with any party who comes to the table in good faith to try to advance this cause. And we appreciate all of the voices in the community, yours, other podcasts that are out there,
Thank you.
people that are working in order to find a pathway and a solution to fight back against the FDA because they're wrong on the science, they're wrong on the policy, and we've got to simply convince Congress and state legislators that they need to act in order to rein the FDA in.
Mac, always a pleasure, always informative, and always a good mental workout. It was great to have you, and we'll do it again someday. Just hang out
Great.
for 1 minute after I end the recording. Kratom Advocacy Podcast, signing out.